And then do you recall that these are 8 murders and 1 attempted murder, right? What you said? Bernard Causey. That is an attempted murder, right? Yeah. Because he didn't die, right? Yeah. But Kelvin Brumfield, you murdered Kelvin Brumfield, right? No, I ain't murdered. My partner murdered him. I had something to do with it. Well, it's like a murder. You pulled him off a fence or something like that? Yeah. And then he was beaten to death that you participated in, and then he was shot, right? Yeah. So you murdered Kelvin Brumfield, right? Yeah. Bernard Causey is the one that you were talking about how you obstructed justice and got away with that one, right? I what? You obstructed justice and got away with Bernard Causey by bribing him not to identify you, right? No, I never was charged with that murder. Breezy was charged with that murder. Breezy was charged with that attempt murder, not me. I never was charged with that. Okay, Kendall Favor, that's a murder that you participated in, right? Yeah, with the guys over there. But they don't have immunity for it, right? No, they don't got immunity. Okay, Rayshawn Jones, that's a murder you committed, right? Yes, with one of them guys over there. Okay, Lester Green, again, murder you committed, right? Yes, with them guys over there. But again, they don't have immunity for it, right? No. But you do, right? Okay, Donald Daniels, that's a murder you committed, right? Yeah, with one of them dudes over there. Again, they don't have immunity for that murder, right? No. But you do, right? Yeah. Elton Fields, that's a murder you committed, right? Yeah, with them guys over there. And again, they don't have immunity for it, right? No. But you do, right? Yeah. Little John Haynes, again, a murder you committed, right? Yeah, with them guys over there. Again, they don't have immunity for it, right? No. But you do, right? And lastly here, Floyd Moore, that's a murder you committed, right? Yeah, with them guys over there. Okay. But once again, they don't have immunity for that murder, right? No, the reason why they don't got immunity for the murder is because, Judge, okay, don't answer that. 8 of those are murders, right? And on the prior page, you agree that you had participated in 3 other murders, right? The murders of Quelton Broussard, Calvin Celestine, and Gregory Keys, right? Yeah. So that's 11 murders, right? Plus Magnolia Shorty and Man Man. I got hit with relevant conduct for that because the government already knew that I had something to do with it. They wasn't going to give me immunity for it. Because you weren't honest with them at that first debriefing, were you? No, it wasn't because of that. It was because they already had leads on that already. So they wasn't giving me no immunity on murders that they got leads on. Okay. So then that's 3 murders that you pled guilty to, 2 that you didn't have to plead guilty to, but that you got relevant conduct for, right? That's what you're saying? Yeah, I pled guilty to 3 murders, but they hit me with relevant conduct for them too. So that's 5 murders that you either pled guilty to or that you got as relevant conduct that you admitted to. And then you have these 8 murders that you just agreed you committed and that you got immunity for, right? Yeah. So that's a total of 13 murders that you committed, right? Yeah. Are there aside from those 13 murders, are there other murders that you committed that you haven't told anybody about yet? Let's have a sidebar conference, please. Okay, the immunity was given for the murders that were included in the factual basis. You're now going into, I know you're given wide latitude on your cross-examination, but statements that if he responds to and specifically are incriminating and he does not have counsel representing him now, would you mind? Because if not, I am not going to allow you to ask that because of legal consultation. I don't have a problem if you say there are other murders that you've committed and leave it like that. But if you are going to try to get into specifics, that could open up for him other problems for which he has not been given immunity and he has to have counsel for that. You can let him talk to his lawyer if you'd like to, and let him decide his answer. Ms. Johnson is here. I understand. Judge, yes. He would have immunity still. If you're telling me that on the record, I don't have a problem with it. Any information he provides in response to questions by federal prosecutors or against, I understand that he is not a federal prosecutor. I need to look at it closer. It's probably best he talk to his lawyer. I'll do this then. While you're here, let me get Miss Johnson up here and tell her what has been my concern and ask her if she would like for me to take a brief recess, and then I will, out of the presence of the jury, quite candidly out of the presence of all of these other defendants, they can go take a bathroom break in the back and let her have a 5-minute conversation with him. I think that's the safest, fairest way to do it. I do not want to deprive cross-examination, but by the same token, this man has to be given his rights. There's no doubt about that. And it's up to him whether or not he is going to waive. Fair enough? Whereupon Sarah Johnson, counsel for Gregory Stewart, joins the sidebar conference. I've expressed a concern when Mr. Southern was going to go into any other murders that were not included in the plea agreement. I feel that he needs to have legal counsel at this point because, quite candidly, he's been, you know the law, we all know the law. He's been immunized as relates to things included in the factual basis. However, he could possibly be fair game for any others, and I'm not going to allow this man to incriminate himself. Although I acknowledge, as you know, as a defense attorney, wide latitude under cross-examination, he is doing his job for his client. But we have a man now who is not immunized, and although he has been required by the government to be honest and that they would not charge him with any crimes for which he spoke with them, Mr. Southern is asking specific questions about other crimes for which he might not have mentioned to the government for which he could possibly be prosecuted for. We don't know that answer. Okay, so here's what I told counsel that I would like to do, and they've all agreed. We're going to go ahead and take our second afternoon recess. Okay. I'm going to have all of the defendants leave, and of course the jury is going to be gone too. And I'll let you speak with him as his current attorney and has been his counsel and representing him on his federal charges, and explain to him what his rights are. And he can certainly, you can't waive his rights, but he can waive his rights if he chooses to. The government did say to me, well, Judge, we can't prosecute him because the plea agreement was that in speaking with federal officials, we all agree with that. But it seems to me he might not have spoken to the federal officials about these other murders, if there are any. There might not be any. Before he went there, and as I told you, I was going to assure you that I would be listening very closely because I was not going to allow this to happen to this man. So with all counsel's permission, I'm going to go ahead and take a recess, and I'll let you do that. Mr. Miller. I object to this. Perry Miller on behalf of Jasmine Perry. I think this man, by testifying today, by entering into a cooperation agreement, by seeking time cuts, has waived any right to a Fifth Amendment in response to Mr. Southern's question. He's been interrogated 17 times by federal agents, and those interrogations, we know from the notes that he was asked each and every time, do you have any information about any more murders? And because those additional murders have not been reported in 302s or any other information, he has either committed perjury to the federal agents or he can answer the question truthfully. But in terms of asserting a partial Fifth Amendment privilege to that question, I think he waived that. So I do object to this process. Okay. I know he had an attorney proffer session and he gave information on an additional murder, a 13th murder in his proffer session that he hasn't testified to yet. Your Honor, for the record, Ms. Johnson has been nodding to the comments you've been making about her representation. I would like her to say on the record that she understands what you're asking her to do. I haven't asked her anything for her to respond to. She'll respond if I ask her. I have no problems with that. Let me finish my initial thought. Mr. Miller, I hear what you're saying, and of course I was not aware of a proffer, and of course it goes to the credibility of this particular person. Ms. Johnson, let me take it one step further. Before you did get here, I did mention to counsel that a suggestion that I had to, so that they would not be limited in cross-examination, but by the same token, so this man would not necessarily incriminate himself to a great extent. I don't know how else to put it, was to allow Mr. Southern to ask, are there any other murders that you didn't tell the government about? But then not allow any counsel to go into specific names of other people because specific names of other people could then generate further investigations with certain other victims, and that is a slippery slope. Okay, before Mr. Southern responded that he would be willing to do that, or any counsel responded that they will be willing to do that, I decided that we needed to call you up here before that. Okay, I've heard now for the first time about this proffer. Could I respond? Before you respond, tell me what you were going to say and you can respond to everybody. I was going to say that I acknowledge that and appreciate that Ms. Johnson is in a sticky situation, but I wanted to note that she is under sequestration. And I respect Sarah, and I know that she would not violate the sequestration order, but it creates a problematic dynamic if she is talking to him about his rights, but is unable to discuss with him his testimony. I have a couple of things to respond to. First of all, with regard to that, Mr. Stewart is currently under sequestration, so no matter what kind of advice I give him as his attorney, it does not include me discussing his current subject matter testimony with him. My advice is legal advice, so there's no issue there. I agree with you. As to the potential remedy, Your Honor, that you had suggested, I agree with you that it's a slippery slope. It's not only a slippery slope potentially for my client, it's very slippery slope potentially for the individuals on trial, because what if Mr. Stewart says, oh yeah, there's other murders and all of these guys were with me, and all of a sudden there's all of this previously undisclosed 404B. It's a surprise attack. So I don't think that that's advisable for anybody. I think from my point of view, well, then we will all have a problem with that. I asked a question fully apprised of the potential downsides. So if the strategic question is Ms. Johnson isn't, I'd just like to add one more point to what I said earlier. Ms. Johnson's proffer session with the government where she discussed Mr. Stewart's involvement in a 13th murder would not be privileged because that was in connection with a proffer session with the government. That was my thought actually, but I've not done any research on it. If he already disclosed or he has not disclosed, Ms. Johnson has disclosed a proffer did not come out of this man's mouth, but came out of her mouth on his behalf. So I guess the legal question, which I'm going to have to think about, is can a proffer be held? Can a person be impeached on a proffer that he is not? I think it's a legal issue that I don't know the answer to. I would say that she attended the session as his agent with his authority. I understand. Your Honor, so it's clear, just some background for you. Before we began debriefings in earnest, as you can tell from the history of this case, Gregory Stewart and his attorneys had a very tense relationship with the government, and this was a very long road down the aisle. And because relations were so tense, how we began this process was by attorney proffer. And I've got one copy I think the latest one here. This has been filed into the record. There was no verbal attorney proffer. Any attorney proffer that I ever did on behalf of Gregory Stewart was memorialized in writing, and it was disclosed to the defense. That's what I am talking about. I am telling you right now, my initial thoughts. My initial thoughts right now are that you can impeach him on the proffer in that you can ask him about a proffer since that has already been. But as long as you characterize it through his lawyer, he made a proffer to him and see how he responds to that, because that name is out there already. So that name is out there already. So I don't see that that would incriminate him any further than if the government wanted to pursue that, since that was not included in the factual basis. So that's my initial thought right now. You haven't spoken with your client, and I understand that. Let me just leave it like that. Mr. Haller, beyond the scope, that murder you're referring to in this proffer, he's admitted it's a spreadsheet. Terrence Davis. Terrence Davis is charged. That's the one that your client is on. He didn't say that he did that. He said he was in the car. He, Jasmine Perry, and Darryl Franklin. But he said he was in the car. No, he didn't. Don't mislead him. Ask him, was he in a car for another murder? I don't want to ask him that. You don't want to ask him. That's not what I am asking. I don't want to feel compelled to ask him. I shouldn't have said ask him. Do whatever you want to do. I am seeing what we can do to protect your client's interests. And 13 is a very large number. Is there a 14th? Or more? Or more? Or 17? And that's the gravamen. But I have no opposition to, I guess Carrie does, so this doesn't matter. I have no opposition to Sarah just saying, what you're doing. I would want to do that with my client. I would like to add this too, as to why I think his question, are there more, is a question that this witness must answer under oath, and that he's waived the Fifth Amendment privilege. Your Honor, there are recorded phone calls, which Billy hasn't gotten to yet, where he references 17 bodies and 19 bodies, which gives us implication that there are more murders out there that he is involved with because he's using the numbers 17 and 19. He used the number 17 in that 302 that I just showed him, because we hear that and he couldn't remember. So can you not, I am not telling you what to do, I am just trying to resolve this. So why can the question not be asked? Hold on, let me finish. I apologize. Apparently, you don't think it's going to be a good idea. But question number 1 is, were there more murders? And if he denies it, then you can still cross-examine him. And what about play this tape? What about the number 17? And then he doesn't have to go into the specific murders or specific victims or whatever, but you've impeached him on 14 or 17. Now, the question right now, he might deny everything, but you have on the tape that you did talk about 17 other murders. I hope to wrap up the history of it. My expectation is I'm going to ask him, is there a 14th murder? And he is going to say no. Okay, but if he said yes, then I think the door is open. The door is wide open to ask him what the 14th murder was, because that would mean he lied in all of his debriefings. I think it's an academic matter. I don't think it's an academic matter. I think it's a matter of semantics and how you're phrasing your question, because murder is a very broad term, and it is a murder that you committed. Is there a murder that you participated in, or is it one that you witnessed? I am asking him about people that he's participated in killing and intending to kill. Then I think that needs to be clear. And he is going to go there. There's a lot of jockeying position. He didn't murder somebody, and then whether he participated in the murder, when we as lawyers know, it's a fine point. It's a fine point, but we don't want anybody to be misled on, especially the jury. Okay, well, first off, Miss Johnson, talk to your client, and then we'll see. Shouldn't he be allowed to ask the question and get the yes or no before she talks to him, because she should only have a right to talk to him if I have no problem with her? I know that, because then they could proceed on impeachment, or I can proceed. If he is able to ask the question before Mr. Stewart is, apprised of his Fifth Amendment rights, then we might as well not even do this. It defeats the purpose. What was the specific question? What was your specific question that you asked? Are there any others? Are there any other murders? That's pretty specific. That raised my attention. Okay. Do you have any kind of good faith basis to be asking him that other than, I don't need a good faith basis to ask him that in cross-examination. I am confused. What is this proffer about? I think it's a fair question. It is a fair question. Certainly it's a fair question. What is this proffer? I am really confused. Is it another murder? Ms. Johnson is correct. She had a proffer session in writing with the government where she created a spreadsheet listing murders that he would have been involved in. Just for clarity's sake, there was a spreadsheet and notes in the spreadsheet written by the agents. I interpreted the spreadsheet and the notes to include an additional murder. If my interpretation is wrong, it's wrong. But I interpreted the spreadsheet and the notes by the agents. The notes are by Sarah Johnson, not the agents. I think you'll find it confusing, but the names in the murder column aren't his victims. They're murders that he purports to have knowledge of. I am looking at the data and trying to count. It's all I'm trying to say. So, number 1, I'm going to take a break. Ms. Johnson can talk to her client. That's number 1. Number 2, I'm going to allow you to ask the question you asked, okay? Thank you, Judge. I am not going to allow you, and I'm telling you right now, and if the Fifth Circuit reverses me, they reverse me. I am not going to allow you to go into specific names of, if the man is truthful, well, if he's truthful, not truthful, if he is inconsistent with the factual basis, I'm going to allow you to go into numbers. I will allow you to go into the question about wiretap or the prison monitor call, whatever it was, the number 17. What did you mean by that, and readdress it at that time? And I might change my mind. I might let you go into greater detail. I don't know yet until we hear what's out there. We are having a hard time hearing what you're saying. I think he's going to say no. And then, but if he says yes and then he refuses to, and then I ask a follow-up question and the court won't allow me to ask the question, I just ask that we be able to recess and debrief the issue before the morning. We're towards the end of the day anyway. Okay. Let's go ahead and take a brief recess and then you can talk to him, okay? Thank you, Judge. All right. Thank you all.